Hey, everybody, and thank you so much for joining us for the interview on Mid-Bay News. I'm here today with attorney extraordinaire, second time I've said that today, John Libby. John, thanks so much for being on, and tell us a little bit about yourself.
Hey, thanks, Christopher. I appreciate the opportunity to be here. I am a local boy. Grew up in Crestview. My folks are still there. Went to Florida State for undergrad and law school, and I've been back here practicing with the same firm, Anchors Gordon in Fort Walton Beach, since 2015.
And so, John, you're a big audiophile, so I think a great way to tell people more about you is to tell us what are you listening to right now? What are you really enjoying?
Well, I'm always big on classical music, so there's always Vivaldi going on at this time of the year. But I'm also equally at home listening to whatever Disney soundtrack my daughter's watching at the moment. So I can
So,
recite all the Frozen lyrics if you like.
I was about to ask you, so like, do you like Vivaldi's Winter better, or would you like to build a snowman?
Right now, right now, I'd like to build a snowman. Oh, sorry, phone rang.
No. What, attorneys are getting phone calls? That's ridiculous. Tell me, my brother, you last we were talking about the differences between Okaloosa County, you know, attorneying, lawyering, for lack of a better term, and the differences it might be obvious to you as an attorney up here from the rest of the state. So, what's unique about Okaloosa County and Walton County, and practicing law up here?
Yeah, practicing in the Panhandle is unique. It's kind of self-preservation in a way. The judiciary here is a small group. The lawyer pool here is a small group. And so, if you're practicing in front of lawyer A today, chances are you're going to see that person again in a case not too far down the road, which is a key distinguishing factor from South Florida, and even Central Florida, where you have literally thousands of lawyers in the southern part of the state. And so, you may never see the same judge or the same lawyer again. And so there's a different level of aggression that you'll see. Um, the lawyers here are far more civil, um, and that's not just a bias. That's well documented in all of the in all the bar literature. It's just, I think it's a function of how we practice and why we're as small a community as we are. We really have to work well together.
And so you said that it's been well documented. Does that mean that, um, I guess for lack of a better term, there are fewer professional conduct cases up here than there are in South Florida?
Well, yes. Statistically, it's a function of there's just more lawyers in the state, in the south end of the state. There's probably a little over 120 lawyers in the Okaloosa Bar Association, and so that is a far cry from the Miami-Dades or the Broward County Bar Associations, where you literally have thousands of lawyers involved in each.
So there's 120 attorneys. Is that, but you wouldn't necessarily go up against all other 119 of them, because you guys practice different forms of law, right?
That's right. So, and that even kind of illustrates the point even further. So, there's a fair number of lawyers who practice in the criminal sector, either for the public defender's office, the state attorney's office, or private criminal defense attorneys. And those lawyers are kind of their own niche group. I practice civil litigation, and so I never really associate or see the criminal side of the bar, um, unless we're at a bar meeting where it's kind of like socializing. So, the lawyers that do the civil litigating that we do, it's a far smaller number. So yeah, you really do see the same lawyers on many of the same cases.
So in your line of work, you specifically practice, civil law and you do civil trials, things of that nature. Can you kind of tell me a little bit about what that looks like for you on a daily basis, and kind of explain the different tiered systems of civil trial and civil law?
Yeah. So, I mean, the cases, there's different tiers of litigation. So you have starting out at the base level, you have small claims court, and those are disputes that are $8,000 or less. And that's not really the world that you'll see many lawyers in. That's kind of where you typically see the most amount of unrepresented parties. It's a fast, expedited way to get disputes resolved. You kicked my dog, or your tree fell over and dented my car. Those are the things that they feel like they need to fight about. But the attorney's fees would very often exceed the amount of the controversy at the small claims court level. So you really don't see a lot of lawyers practicing there. The next tier up from there is county court, so that's $8,001 up to $50,000. Those jurisdictional limits have been increased, so that's allowing more litigants to get their cases resolved at the county court level. County court cases move a lot faster than the circuit court. Circuit court's the next tier up. And so once you're over $50,000 and beyond, then you're in circuit court. And so we spend the most amount of our time in circuit court. We have a total of 6 circuit court judges in Okaloosa County, 3 county court judges. And it varies. The type of dispute that you have will govern what type of venue your lawsuit is brought in. So if it's a simple landlord-tenant type case, you'd be in county court. It's pretty quick.
Why does circuit court take longer than small claims court? Is it just a number of hoops jump through, or because?
Well, so the civil context, if you're in small claims court, there are statutory rules in place to make the process as streamlined, as efficient as possible. So there are certain motions that you don't get to file in a county court case, just to kind of keep the costs low. But if you're litigating in county or circuit court, you have to be given the opportunity. We're big on due process in the United States. We've got a very good litigation system in place to protect your due process rights. So that involves, discovery, allowing to take depositions, subpoenaing documents. Those are the sorts of things that you can get into once you're in a higher dollar dispute. And it really varies on the type of case. If you've got hundreds of witnesses or dozens of witnesses, that's obviously going to drag out the time it takes to litigate a case. So it's case specific.
Speaking about the smaller courts, we have talked previously about the kind of the risk and the reward that individuals are going to see for hiring an attorney or not hiring an attorney, especially in a smaller claims setting. Can you talk a little bit about what the risk versus the reward is in a smaller setting, somewhere kind of in that amorphous zone between the top end of small claims court and the bottom end of county court?
Yeah, so I mean, of course, the downside, it's a mathematical calculation. If you're going to hire counsel, that of course comes at an expense. And so really, if you're talking about if you're arguing over a $2,000 dispute, it really doesn't make a great deal of sense, to litigate that dispute, because the costs you're going to incur are going to exceed the amount of controversy. And this is not a well-known fact. I get a lot of people that are confused about this, but in the United States, we follow the American rule on attorney's fee recovery, which means even if you win at the end of the day, you bear your own fees and costs. That's different than the European model, where the winner gets his legal fees covered by the losing party. So you can have that in the United States, but your contract specifically has to allow for prevailing party attorney's fees, or there's a statute that applies. But I would say in most contexts, you're stuck bearing your own fees and costs. So that's the downside. But I would say the upside is, if you're litigating against an unrepresented party, you have an immediate advantage. I'm not saying that you win all the time, but the lawyers know the rules. Presumably they do, and that gives you a better ability to maneuver against the other side. And so, again, the judges here will give unrepresented parties their fair shake. But again, if you choose not to hire a lawyer, you're still governed by the same rules of the legal process. The evidence that comes in, has to pass muster. You don't get special treatment in that regard simply by being unrepresented.
You don't get to play with the handicap, basically.
That's right.
Okay, and so one of the, I think, most common legal disputes, at least that we've talked about, is that I guess it really just kind of evolves around real estate and real estate transactions, especially right now as we're seeing kind of a shift in the market. Can you kind of run me through how real estate disputes that you see get started right now anyway, and what the recourse looks like? And then can we talk a little bit about the Johnson v. Davis case that kind of like sets standards on duties to report?
Yeah. So I think your summation is pretty apt. There's a lot of real estate litigation that occurs in the Panhandle that takes a few different forms. As you mentioned Johnson v. Davis. That is the classic non-disclosure case. It's a Florida Supreme Court case from the early 90s that states that sellers of residential real estate have to disclose to a prospective buyer known issues that aren't readily observable. So, if you happen to know that you've got a bunch of termite damage, but that's not seen by the naked eye, you can't just sit there and rely on the as-is language in your real estate contract. You have an affirmative duty under this Johnson v. Davis case to actually disclose those issues to a prospective buyer. So you get a lot of litigation related to that. There's a fair bit of construction defect litigation that goes on in the Panhandle. And then I would say the third tranche of litigation just happens to be buyers and sellers of real estate trying to get out of their contracts. In this situation, it's kind of dictated by market conditions. In seasons where the real estate market is super hot and the property values are appreciating, so think the COVID era, you saw a lot of sellers trying to get out of their contracts because, I would say there's no hard and fast rule, but I would say that after you sign a contract to sell or buy real estate, if you're financing the transaction, it's usually between 60 and 120 days before you actually get to your closing date. And so, back when COVID was here, property values could increase fairly substantially in that 120-day period. And so you would find sellers wanting to get out of contracts at that point because they can chase a bigger and better deal. The reverse is true in the situation we find ourselves in now, where the real estate market has slowed down. you've got a lot of buyers who are trying to back out of their contracts because the property that they contracted for is perhaps not as valuable as it was when they signed the contract a few months ago.
the this court case, when it applies to residential homes, does that mean that it applies only to residential homes that are being used for the buyer's primary residence?
No, the holding in that case applies to any residential property. It can be used for a rental property, but if it's a single family type residence, Johnson v. Davis applies. It does not apply to commercial real estate. So if you want to be a shopping center landlord or something like that, presumably you have the wherewithal and the knowledge to fully investigate a purchase before you buy it. But there's that extra layer of protection if you're in the residential context.
Is that, and I guess I'm asking you to look into the legislature's mind, but is that because you don't want to dissuade people from buying residential homes?
Well, I think it's a policy decision that takes into account that your average buyer probably lacks the financial resources to flip every stone that's unturned to figure out what's wrong with the property. If this is your first time buying a house, and most of your money is being used for a down payment or what have you, you probably don't have the excess cash to hire an engineer or do a really in-depth property inspection. You definitely can do property inspections, and most lenders will require you to get an inspection, but those are more superficial, surface level inspections. Most of those reports will say, hey, listen, I see an issue. You should hire somebody with more credentials to go investigate further. And a lot of people don't do that.
So switching gears a little bit to your time, which is most recently ended as the Okaloosa Bar Association president, can you kind of tell me, but also people that are listening, what a bar association is and what it does?
Yeah, absolutely. So the Bar Association, and every county in Florida's 67 counties has a bar association. The purpose of the Bar Association is to provide an opportunity for the lawyers of the community to kind of come together, not only in a social perspective, but also to kind of expand your knowledge and provide your local lawyers with resources to help them in their career paths. So I would say that our bar association for a lot of years used to be a kind of a social only type event. You meet for drinks, you just kind of talk shop, which is great, and we still do that to this day. But we now provide more content for our members, continuing legal education, various other opportunities to get some benefit out of this out of their membership with the bar.
What kind of continuing education do you find is necessary for an attorney to kind of like stay sharp?
Well, every 3 years, the Florida Bar mandates that every lawyer, well, not every lawyer, there's some exceptions, but most lawyers have to go through over 30 hours of continuing legal education. And so it doesn't matter how long you've been in practice. So a lot of it has to do with developments in the case law, laws, not only statutes, but court decisions, they change over time. So, the state of the law that was in existence in 1987 may not be the prevailing view at the time. So it's an opportunity to get caught up on developments and not only legislative updates, but also case law updates. The Florida rules of civil procedure, the rules that lawyers go by, those will change periodically that really have an impact on how we do our jobs. So those are the sorts of things that we do. And there's always, there's a there's usually a professionalism requirement, usually thanks to a need from the south end of the state. But the bar has saw fit that professionalism training is useful for all lawyers to have.
I've got to ask what defines is it like basically, hey, don't like hop over the bar and like take a swing at the judge kind of thing, or is it more like your salad fork goes here? Like,
Well, it's so in litigation, right? It's a high stakes kind of situation. You've got your clients who are in the middle of a really big legal predicament. The stakes are high, and your clients are wanting you to advocate as best as you can for them. And so sometimes I think that zealous advocacy spills over and crosses the line into hostility, which just makes the overall practice less efficient and actually more burdensome for the litigants. So, I mean, simple things like trying to accommodate scheduling requests. If some lawyers have scheduling conflicts, if you need more time to respond to, discovery requests, things of that nature, those are things that lawyers around here will routinely do. I would say elsewhere in the state, that's not always the case, where it's, man, I'm not going to give you an inch. There's, what's going on in your personal life has no bearing on my case. That's the sort of civility dispute that we sometimes see. Just the nature of most cases, the lawyers are going to spar with each other just because you've got a view of the case and a view of the facts that's going to be contrary to your opponent. But there's no reason why you can't go out for drinks with your opposing counsel after the day is done. That's
at least
what we
there
do
shouldn't
well.
be, right?
That's
like,
right. That's right.
And so, talking about colleagues and things like that is a big military area. I'm sure that you guys have a lot of contact with the military. Can you tell me a little bit about what the Bar Association does to kind of work with the military and how we might see that here on the civilian side, some of the results of that?
Yeah, and that's something I'm actually kind of proud to put a point on. During my term with the Bar Association, we saw an increase in the level of engagement between the civilian bar and the military bar. For a lot of years, it's the civilian lawyers. They operate in different spheres. You're never going to see legal disputes, or more often than not, you're not going to see the same legal disputes that Eglin or Seventh Group deals with. They've got their own process, their own rules of military justice. So they have an entirely different process for resolving their disputes. But, as a local bar association, we thought it was important to kind of foster some collaboration between the civilian bar and the military bar. The military lawyers and military service members generally are transient. They're here for a few years and then they're gone. And so, but just like any other person, they have legal disputes, and the ability for us to communicate and provide the service members with contacts for people who need legal assistance on the civil side and what we do, that's always a good thing. Sometimes service members get into legal trouble, whether it's a speeding ticket, a DUI, some other sort of criminal law matter. We've got a good contact list of criminal defense lawyers that they can use. There's a fair number of military service members who transition out of the military and they've got ambitions for some business that they're trying to develop. And so we can connect those military service members with civilian practitioners to help them get their business off the ground. And so, we're trying to make sure that there's a point of contact for every legal need that the service members need.
Um, we talked briefly about spouses of military members that might have admission to the bar and other places. Can you explain, like, if I have a bar license in, am I saying that right? Bar license, licensed bar.
Yes.
So if I'm licensed in Georgia or Connecticut or wherever, and my spouse moves to Eglin or Hurlburt, uh, it, am I able to practice law here, or is it kind of like I have to take the bar exam all over again?
So in your hypothetical, yes, your spouse would be able to, or you would be able to practice law in Florida, so long as your spouse is stationed here in Florida. That would be different if you had a civilian couple from Georgia and the civilian took a civilian job here. Florida doesn't offer reciprocity from other states, but there is this really helpful exception that's only a couple of years old now that allows spouses of military service members to practice in Florida without sitting for the bar exam, which has really, I think, been helpful for our bar association because there's a need for lawyers, particularly in our area, and so being able to kind of fill some of those gaps with lawyers that have come into our area by happenstance, to put them to work and put them to use in our community. So that's been helpful.
And so is it, is the law different enough in other states to where it could be a major impediment to some of those attorneys to practice well?
You know what? I don't think so. Anytime that you come from a different jurisdiction and you're finding yourself here locally, you have to practice under the supervision of a licensed Florida attorney. It's not as if we cut you loose
Okay.
and you figure it out on your own. So there's some guidance there to make sure that your foreign attorney practicing in Florida is not set up to fail. I would say on the whole, I think it's been a positive development. There's actually a fair degree of variance in how other states and other jurisdictions operate their judicial systems, and so it's kind of like a marketplace of ideas. You hear about, man, they really do something well, in Colorado, or man, the folks in Georgia, they've got their whatever the issue might be,
Appellate's
but
figured out or something. Is that a thing? I'm way out of my depth.
not yeah. Well, that's another that's another show. But I would say that just there's certain rules and just a different way of practicing that it is actually useful to hear how other states do it, and it either makes you appreciate how we do things here, or it gives you the motivation to try to get the rules changed in Florida to mimic
Cool.
a state that does it better.
Perfect. Last question, kind of in this vein, is the differences between like Florida courts, right? And the only different one I can think of civilly is like Napoleonic Code in Louisiana. Is it kind of like if you speak French and you hear somebody speaking Italian, you kind of know what's going on with like the military? Like if you hear them talking about the Uniform Code of Military Justice, you're like, oh, okay, yeah, like, I understand how basically a criminal trial works in the civilian side. Would you be able to like translate what's going on the military side? And the same thing, I guess they don't really have a civilian side though, or a civil side though, do they?
No, but I would say that the military, the Code of Military Justice, the military in general is big on acronyms, and so I can tell you based on my limited interactions with the practitioners, on the military side, they operate in a very different process and procedure than we do here in Florida. So, while I can speak the same language as another civil lawyer from another state because a lot of those concepts are universal. That doesn't necessarily translate on the military side.
Got it. Last question for you. What do you wish people knew about attorneys in Okaloosa County generally?
Well, the lawyers here are we care about our clients, right? So it's personal to us. We take I think I can speak for most of the lawyers in our area that we want to give our clients the absolute best efforts that we can to advance their legal interests. And so I think a lot of lawyers here take that to heart. You're not just a number. We definitely want to show you or give you the best outcome that we can, and we give you our best efforts to do that.
All right. Well, John Libby is a partner with Anchors Gordon in Fort Walton Beach and a wonderful Niceville resident who has humored me by coming on to our podcast today. So I really do appreciate your time, brother.
Thanks, Christopher. Appreciate it. Happy New Year.
Happy New Year.